हाँ भाई, तो लास्ट क्लास में अपन आर्टिकल 19 तक देख लिया था। आर्टिकल 19 में अपन ने आर्टिकल 19(1), आर्टिकल 19(2), आर्टिकल 19(3), आर्टिकल 19(4), आर्टिकल 19(5) and as well as article 19(6). All we have discussed in the last class. Now we are going to discuss about the article 20 of the Constitution of India. So let's move and discuss it in a very detailed form. What do we mean by article 20? As we have already told you that you have to purchase this book, because I am teaching from this book. This is the Bayer Act of Constitution of India, and all UPSC syllabus of the polity I will cover from that book. So now, Article 20 of the Constitution of India. For the Article 20 says, Article 20 says that protection in respect of conviction for offense. So basically it talks about protection if convicted of an offense. Basically, let's suppose you have been arrested by the police or by the another authority. Then what the protection will be given to you if you will have been arrested by the police? Then what should be the right enjoyed by you and what the rights should not be enjoyed by you? So these are the basically rights which has been given to you under Article 20 of the Constitution of India. So basically what the Article 21 says, first read in. So basically what the happened, let's read once that. So basically let's suppose you have committed a crime. If you have committed a crime, then in the first situations, the conviction in an offense will be offered on you. So basically first situation क्या होगा, conviction होगा. Conviction in an offense, let's suppose you have convicted, then you sent to the jail, and if you sent to the jail, then your freedom will be restricted. So basically direct effect your freedom. भैया मान लो तुम जेल चले गए, तुमने कोई क्राइम किया, तुम जेल पहुंच गए. जेल पहुंचने के बाद तुम्हारी फ्रीडम तो डायरेक्टली इफेक्ट हो रही है ना. अब तुम्हारी फ्रीडम अगर डायरेक्टली इफेक्ट हो रही है तो ऐसे क्या तुम्हारे पास राइट है जो कॉन्स्टिट्यूशन तुमको देता है कि भाई ये तुमको प्रोटेक्ट मिलेंगे. सो व्हाट इज द राइट, व्हाट इज द प्रोटेक्शन हैज बीन गिवन टू यू इफ you are in the jail, if the crime has been convicted against you. So what the right you have, so that has been given in the Article 20 of the Constitution of India. So let's first read Article 20 of the Constitution of India, then we will discuss. So basically it talks about protection in respect of conviction for offense. So basically it talks about if you have committed an offense and what is the protection has been given to you after committing the offense. So in Article 20 there are three clauses: Article 21, Article 22, Article 23, Article 20, no Article 20, only Article 23. Okay, so now these have Article 21, Article 22, Article 23, Article 20 subclause 1, Article 20 subclause 2, Article 20 subclause 3. Now first read what Article 20 clause 1 says. Article 20 clause 1 says that no person, whether it is a citizen or any foreign person, so it applies for both the persons. So it says that no person shall be convicted of any offense except for violation of a law in force at the time of the commission of the act charged as an offense, not nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of commencement of the offense. So basically Article 21 says, ये simple बात हम समझते हैं. Article 21 says no ex facto, no ex post facto legislature, no ex post facto legislation. कौन सी अंग्रेजी लिखती है ये नहीं समझ में आ रही. इसका सिंपल ये मतलब है भाई कि मान लो आपने आज कोई क्राइम किया, मान लो आपने एक मर्डर कर दिया, उस मर्डर की सजा मान लो आपको लाइफ इन प्रिजन में थी। अभी तक जो लॉ थी उसमें क्या था कि आपने एक मर्डर किया, आपने मान लो, मर्डर तो बहुत एक्सट्रीम हो गया, आपने चैन चुरा ली, चोर आदमी, चैन चुराने की सजा मान लो 2 साल थी अभी तक। अब तुमने चैन आज चुराई है, चैन तुमने आज चुराई है, कल पार्लियामेंट जाती है और लॉ बनाती है कि भाई अब चैन चुराने वालों को 10 साल सजा मिलेगी। लेकिन चैन तो तुमने पहले चुराई है, लॉ बाद में बना है। तो बेसिकली इट सेज कि जिस समय आपने चैन चुराई, सजा उसी के हिसाब से मिलेगी। सो बेसिकली इट टॉक्स अबाउट if you have committed a crime on a particular date, then procedure will be followed on you on that law which has been on that particular time, not on the upcoming law. So basically, if you have committed a crime, let's suppose crime has been committed at what is the date of today's 21st March 2026. So let's suppose crime at 21st March 26 को आपने कमिट किया। उस समय सजा इस क्राइम की थी मान लो 2 साल, 2 ईयर। अब कल अगर पार्लियामेंट जाए और एक लॉ बनाए कि भाई 22 मार्च को अगर पार्लियामेंट लॉ बनाती है और कहती है कि भाई इस क्राइम की सजा, क्राइम की सजा जो है 5 साल है, पनिशमेंट जो है 5 ईयर है, तो ये 5 ईयर की पनिशमेंट जो है ये आप पे लागू नहीं होगी, क्योंकि आपने क्राइम 21 मार्च को किया था, लॉ बनी है 22 मार्च को, तो जो आप पे नियम लागू होगा वो ये वाला लागू होगा, ना कि ये वाला। अब जो 22 मार्च को क्राइम करेगा उस पर ये नियम लागू होगा। तो बेसिकली इट सेज बेसिकली दैट it article 21 says that you can't punish a person by a law enacted after crime. That is the basically mean that it basically says article 21 will not be enforced retrospectively. So that is article 21 does not apply retrospectively. बेसिकली आज आपने लॉ बनाया, वो लॉ अब से लागू होगी। ऐसा नहीं है कि कोई क्राइम पहले हुआ था और आज आपने लॉ बना दी, अब वो क्राइम पे भी तुम ये वाली लॉ अप्लाई कर दो, नहीं, दैट्स नॉट अ वैलिड पॉइंट। बेसिकली अगर क्राइम पहले हुआ था, उस समय जो लॉ एग्जिस्ट करती थी, उस लॉ के अनुसार उस क्राइम को सजा मिलेगी। आज आपने उस क्राइम के रिस्पेक्ट में कोई एक नई पनिशमेंट ले आए हो, तो उसके हिसाब से पनिशमेंट अब जो क्राइम होंगे उस पे मिलेगी। तो बेसिकली दैट्स द आर्टिकल 21 सेज। सो दैट इज प्लस ऑल्सो आर्टिकल 21 says also one thing. What is the article 21 says that no person shall be convicted of any offense except or violation of in a law enforced that a time is commencement of the act charged as an offense not be subject to a person greater than. So basically it also states that you can't punish, you can't give punishment greater than existing law. Basically article 21 says two things. First, let's suppose you have committed a crime today and parliament made a law for convicting that person after the crime has been happened, then the law will not apply to that person. First thing. Second thing is it says judiciary cannot give punishment, or you cannot give punishment greater than the law which has been mentioned on a particular crime. मान लो आपको चैन चुराने की 2 साल की सजा थी, ये लॉ में मेंशन था। अब आप ऐसा नहीं कर सकते कि आप गए उसको 3 साल की सजा दे के चले आए, नहीं। 2 साल की सजा लॉ में मेंशन है, आप 2 साल से ऊपर सजा नहीं दे सकते, पहली बात। दूसरी बात, आप आज लॉ बनी है, उस आज लॉ बनी है तो आज से वो अप्लाई होगी, ना कि उसके जो पहले क्राइम हुए उन पे भी तुम अप्लाई कर दो। दो बात, दैट इज द आर्टिकल 21 से। नाउ लेट्स मूव आर्टिकल 21 टू 22 of the Constitution of India. So we have understood Article 21. Now let's read about Article 22 of the Constitution, Article 20 plus 2 of the Constitution of India. So it says that no person shall be prosecuted and punished for the same offense more than once. So basically it talks about if you have committed a crime. Let's suppose you have committed a crime and you have murdered someone, or you have tried to murder. Then criminal proceeding has been started against you. Now district court has been punished you for the 5 year imprisonment. Let's suppose 5 year imprisonment has been punished by the district court on you, and and think, and you have passed 5 year jail after judgment of the district court. आपने भाई 5 साल का जेल काट लिया। अब अगला पर्सन आया और उसी मर्डर के बिहाफ पे गया हाई कोर्ट कि भाई इसने क्राइम किया था, तो सेम क्राइम था, सेम क्राइम में आपको एक बार सजा मिल चुकी थी, अब उसी क्राइम पे दोबारा सजा नहीं मिल सकती। सो बेसिकली इट टॉक्स अबाउट नो पर्सन शैल बी कन्विक्टेड shall be prosecuted and punished twice for same offense। हाँ, एक बात याद रखनी है बाबू, एक बात क्या याद रखनी, एक बात ये याद रखनी है कि मान लो आपने एक क्राइम किया, उस क्राइम में आपके ऊपर धाराएं लग गई, रेप की, मर्डर की, और रेप, मर्डर, चोरी की, या थीफ की, या आपने एविडेंस को एबॉलिश किया। तो अगर मान लो ये 3-4 धाराएं एक साथ लगी, मान लो आपने कोई क्राइम किया, सेम क्राइम में आपके ऊपर 3 धारा लगी, मान लो आपने थीफ किया, आपके ऊपर रेप का लगा चार्ज, आपके ऊपर मर्डर का लगा चार्ज, आपके ऊपर एबॉलिश ऑफ एविडेंस का लगा, तो मान लो ये आपके ऊपर 4 धाराएं लग गई। लेकिन ये चारों धाराएं लगी तो सेम क्राइम पे है, लेकिन काउंट अलग अलग होंगी। लगी तो सेम पे है लेकिन काउंट अलग अलग होंगी, तो ये माइंड में रखना है कि दीज आर बेसिकली डिफरेंट। इफ लेट्स सपोज यू हैव कन्विक्टेड फॉर द रेप फॉर 2 years, then again you can't be convicted for rape, but you can be convicted for the thief in the same offense. That's a very particular point. I think it will remember. So that is the basically case. But remember one thing also, that is the first point. Second point is also it says that let's suppose you are a police officer and you have murdered someone. Then first proceeding will be initiated by you in the judiciary. That is the separate authority. So one punishment have you got by the judiciary. That is the different. But it may be a possibility that departmental inquiry can be happen. So Supreme Court says that judiciary is the different authority, department is the different authority. In judiciary, on the same particular matter, twice prosecution cannot happen, but on other authority it can happen. So basically, for committing a crime, first proceeding that in the judiciary it can be happen prosecution, and it may be happen that for the same crime, departmental inquiry can also be happen by the police department. So it may also be a possibility that is for same crime, quasi judicial body can also initiate proceeding for same crime. Now it will be okay to you. Now let's read Article 23 of the Constitution of India. So let's read Article 23 of the Constitution of India. What's the say? No person accused of any person shall be compelled to be a witness against himself. So basically it talks about कि भाई मैं अपने ही केस में खुद के अगेंस्ट गवाही नहीं दे सकता. मान लो it says about if मेरे ऊपर केस की प्रोसीडिंग चल रही थी और मैं आप अपने ही खिलाफ कोर्ट में गवाही नहीं दे सकता. सो इट बेसिकली टॉक्स अबाउट नो पर्सन accused of an offense. So basically, no compulsion to be a witness against himself. So basically, person cannot be a witness against himself. It can be a possibility, and it may be a possibility that it will be applies only to written and oral testimony, not by factual evidence. Basically it says about that भैया कोर्ट में जो प्रोसीडिंग्स होंगी उसमें जो एविडेंस होगा वो ओरल होगा या रिटन होगा. आप जाके डीएनए टेस्ट लेके पहुंच गए तो ये मान्य नहीं होगा सुप्रीम कोर्ट में. या आप जाके पहुंच गए कि भाई इसका सिग्नेचर है या फिंगरप्रिंट लेके पहुंच गए तो दैट्स नॉट अ वैलिड पॉइंट इन द सुप्रीम कोर्ट और द हाई कोर्ट और द डिस्ट्रिक्ट कोर्ट फॉर द प्रोसिक्यूशन कैन बी स्टार्टेड इन द डिस्ट्रिक्ट कोर्ट और द हाई कोर्ट और द सुप्रीम कोर्ट. बट it in the Supreme Court they also stated that court does not consider, basically court it says that court does not consider self confession as a strong evidence. मान लो आप थाने में गए, आपको पुलिस वाले ने मार मार के आपको अगेंस्ट में ही बुलवा लिया, तो कोर्ट वो एविडेंस नहीं मानेगी स्ट्रॉन्ग एविडेंस. इट विल नॉट बी अ स्ट्रॉन्ग एविडेंस. बट let's suppose what about the lie detector test, various tests has been happened by the police department, so what is the importance of that? So basically let's suppose lie detector test हो गया या पॉलीग्राफी हो गया या नार्को एनालिसिस हो गया, पॉलीग्राफी या नार्को एनालिसिस या ब्रेन मैपिंग. So these tests are can be used as the evidence in the Supreme Court or the High Court or the District Court. So Supreme Court says no. These cannot be used as an evidence. हाँ एविडेंस के रूप में नहीं यूज होंगे, लेकिन it can be useful to collect the factual evidence. Basically lie detector test has been happened, or let us suppose narco analysis test has been happened. If narco analysis test is going on, then it may be a possibility that you will speak the truth. And while speaking the truth, it may be a possibility that you can express yourself in a truth way. So you can tell, it may be a possibility that you can tell that I have uh, I have thrown that evidence in that place, I have thrown that evidence in that place, I have thrown that evidence in that place. And it may be a possibility that it may be correct. And if you go to that place, it may be a possibility that you find the real evidence which can be used as a as a pure investigation. So that's the basically lie detector polygraphy test as known in the Supreme Court of India. Now, because why it cannot be used? Because right to privacy is a fundamental right under Article 21 of the Constitution of India. So that's the basically Article 20 says. Now let's discuss Article 22 before discussing Article 21. So first we will discuss Article 22, then we will discuss Article 22 of the Constitution of India. So let us discuss Article 22 of the Constitution. So what the Article 22? Let's read first, then we will discuss later on. So basically Article 22 says that protection against arrest and detention in certain cases. So basically it says it provides safeguard with respect to arrest, detention. So basically it provides the safeguard for the arrest and the detention. Basically, what do we mean by detention? You have arrested before the crime on the mere possibility. So it may be a possibility that if you will free, then it may be a possibility that you can commit a crime. Or your presence can be a possibility for committing a crime. On the mere possibility, you can be detained. So basically, what do we mean by arrest? So basically, arrest is a punitive statement which is in Article 22(1) and 22(2). And detention is basically a preventive to prevent the crime. And this is arrest for, it is basically for prevent the crime, and it is basically for after committing the crime to give the punishment. So this is basically you have committed the crime, then punishment proceedings has been initiated against you, then what is the safeguard has been provided to you. That is the mean of arrest. And what is the mean by detention? Before committing the crime, your arrest has been happened, and then what is the safeguard which has been provided to you by the Article 22? So first, Article 22(1) says that any person who is arrested must be informed the ground of arrest. So basically, if you have arrested the person, then I have a right to know on which ground you have arrested me. Plus, Supreme Court also in the Article 22(1) says it also states arrested person allowed to consult with legal practitioner. So basically, Article 22(1) says that any person who has arrested must be informed the ground on which you have arrested the person. Plus, it also stated arrested person have the right to consult with the legal practitioner, basically advocate. What the Article 22 says that Article 22 subclause Article 22 clause 2 says that police have to present arrested person before magistrate within 24 hours. If further custody required, then magistrate approval requires. So basically, Article 22 subclause 2 says that if police has arrested a person, then it is the duty of the police, sorry, it is the duty of the police to present the person before the before the magistrate within the 24 hours, excluding the holiday, excluding the time taken by traffic. So basically, Article 22, 1, Article 22, Clause 2 says about the safeguard which the person has been arrested. Article 22, Clause 1 says that any person who is arrested must be informed of his arrested ground, first arrested person allowed to consult with legal practitioner. That are the two provisions which talks about Article 22, Clause 1. Article 22, Clause 2 says that police have to present the arrested person before the magistrate within 24 hours. That is the basically Article 22. 1, Article 22, Clause 2 talks about the safeguard for the arrested person. Now let's talk about the offenses. We will discuss what is the preventive. So first let us see how many type of offenses are there. So basically offenses can be categorized into 6 variations. First, cognizable offenses, non-cognizable offenses. One category can be this, that basically cognizable offenses are the serious offenses. That is, in these serious offenses, filing an FIR, filing a FIR by police is mandatory before by police is mandatory. Then preliminary inquiry begin by police, and police can arrest the accused person even without warrant. So if you have committed a cognizable crime, basically serious crime, then it's mandatory for the police to register the FIR. Plus, let's suppose you are a accused persons and there is a doubt on you, then police can even arrest you even without FIR, even without warrant. But in the non-cognizable offense, these are the basically non-serious offenses. मान लो तुमने गया और तमाचा मार के चले आए, सो सीरियस तो है लेकिन इतना सीरियस नहीं है, नॉन सीरियस ऑफेंसेस. सो बेसिकली इन दिस ऑफेंसेस, first first primary investigation happen, then FIR registered. But in the cognizable offenses, it is mandatory for the police to register a FIR. If they are not registering, then you can approach the district court directly that this is the person who is not registering my FIR. So this is the basically cognizable and non-cognizable offense. But Offenses can also be categorized into two other forms. That is the first, compoundable offense and non-compoundable offense. Compoundable offense and non-compoundable offense. What is the compoundable offense? Basically, it these are the offenses where party can compromise. हाँ भाई ठीक है यार, दो पार्टी आई लड़ती हुई रास्ते में, थाने पहुंची। हाँ, अगर पॉसिबिलिटी है कि भाई सुलह कर ले यार तू पहले, अगर सुलह हो जाती है तो ठीक है भाई, एफआईआर लिखने की कोई जरूरत नहीं है। पहली बार, सो पार्टी कैन compromise or can negotiate or can negotiate. In non-compoundable offense, basically no compromise can be possible. Basically, if there is any two party and one party murdered another party, then no compromise can be possible. But there is a two party, one party has, then there is a possibility that there can be a compromise, then it is known as the compoundable offense. There is one another category, that is offense, bailable offense, non-bailable offense. So what do we mean by bailable offense? In the bailable offense, basically they are the less serious crimes, and these are the serious crimes. But in the bailable offense, you in the bailable offense, bail, it is your right. Basically, it in the bailable offense, it has your right to demand the bail on the magistrate, and magistrate must have to give the bail. That is the basically right. You have the right to get bail, but in the non-bailable offense, you have no right. It's depend on the magistrate. So there is definition, clear cut definition. In the bailable offense, you have a right to get bail, but in non-bailable offense, it's basically depend on the magistrate. So that is the difference between bailable offense and non-bailable offense. So basically, bail is, to get bail is your right, but here to get bail is not right. Even magistrate can deny, or magistrate can also give the bail. It another processing. It can be a possibility on the uh, possibility of the magistrate. Now we have discussed offense. Now let's discuss what is the process has been followed after the arrest of the person. So basically, process in case of cognizable offense. 1 second. ए भाई करो, पानी डाल देना। Now we are discussing what the procedure has been followed in the cognizable offense. So basically, let's suppose you have committed a crime and police got to you that you are the person who have committed the crime. Then what is the proceeding will be followed? So basically, You are a person, police will arrest you, and it will represent before the magistrate within 24 hours. Within 24 hours. But what about 24 hours? So within 24 hours, you will be presented before magistrate. But for these 24 hour, interrogation will be happen. Interrogation by police. But within 24 hours, let's suppose you have committed a crime, and for 24 hours before arrest, you have to present before the magistrate. But for 24 hours, police can investigate you. So magistrate, then charge sheet will be so accused with charge sheet. Now police will file the charge sheet against you, and then debate will be take place. Debate will be take place on your चार्ज शीट. अभी चार्ज शीट फाइनल नहीं हुई है, अभी केवल पुलिस के द्वारा चार्ज शीट दी गई कि भाई ये चार्ज इसके ऊपर लग सकते हैं. अब इसके बाद चार्ज शीट पे डिबेट होगी कि भाई इस पे से कौन कौन से चार्जेस लग सकते हैं, कौन कौन चार्जेस नहीं अब लग सकते हैं. सो बेसिकली नाउ द डिबेट विल हैपन, देन charges will be final. Charges will be final. Then trial will happen. Trial court. If you got bail, then okay. If you not got bail, then deniable. Then you will go into judicial custody. But within the meantime, police can also demand before filing the charge sheet for the police can demand for interrogation for 15 days. So basically, this is the proceeding which has been followed. Basically, if you are arrested, then within 24 hours, you will be presented before the magistrate. Then police will file the charges against you, and police may demand from magistrate to give that person for the interrogation. If magistrate agree, then they can give, or if they not agree, then they may not give. And after filing the charge sheet, the debate will take place on the charge sheet, and the charge sheet will be finalized. And after the charge sheet will be finalized, the trial will happen. And after the trial will happen, it may be a possibility that you can get bail on the nature of your crime, and it may be a possibility that you cannot get the bail. If you not get the bail, then you will go under the judicial custody. So this is the basically Article 22 clause is procedure which is followed by the Article 22. Now we have discussed Article 22 1, Article 22, and we have also discussed various offenses, and we have not discussed till now for the punitive, preventive. We have discussed about the punitive. Now we have discussed about the preventive. So basically, Article 22 3 says about what the article we have discussed. Article 22 clause 1, Article 22 clause 2. Now let's discuss about Article 22 clause 3. So what is the Article 22 clause 3 says? Let's discuss. Nothing in clause 1 and 2 shall apply to any person who is at for the time being in the enemy alien, to any person who is arrested or detained under any law providing for preventive detention. So basically, it provides protection under Article 22 clause 1 and 22 clause 3. So basically, it says it will not, these articles will not apply, these articles will not apply to enemy alien. What are the enemy aliens? Basically, person whom with India in a war. Basically, let's suppose India and Pakistan war is continuing, and you have arrested a person who is belonging from the Pakistan. Then these safeguard will not apply to that person. First thing. Second thing, Article 22 clause 3 says that safeguard under Article 22 clause 1 and 22 clause 3. So basically it says it does not extend to preventive detention. That is preventive detention, that person arrested on ground of mere possibility of committing a crime. So basically these safeguard will not apply on the preventive detention. Is that clear? So Article 22 clause 1 says that if you have arrested a person, then you must have to tell him the ground on which you have arrested. Second, the person has the right to consult with legal practitioner. Article 22 clause 2 says that police have to present the arrested person before the magistrate within 24 hours. And we have also discussed various type of offenses, and we have also discussed Article 22 clause 3 says that protection under Article 22 clause 1, 22 clause 2 will not apply to alien member, that is India whom with war is going on. And also it states that safeguard which has been provided to under Article 22 clause 1, Article 22 clause 2 will not apply for the preventive detention. So these are the safeguard which has been provided under the Article 22 clause 1, Article 22 clause 2. Now let's move further. So what do we mean by preventive detentions? We have known that, but remember one thing, who have the authority to make law on the preventive detention? So basically both state and parliament both can make law for the preventive detention. So basically now we will discussing about the preventive detention. So basically who have the power to make law? Parliament and state legislature both have the power to make law on their subject. And state have power which has been mentioned by Schedule 7 in List 3 and Entry 9 of List 1 of Schedule 7. Give power to the Parliament. It basically give power to Parliament. It basically give power to state legislature. So both can make a law regarding to preventive detention. Parliament have also power, state legislature have also power. State legislature can make law on the list on the subject which has been mentioned in the list 3 of the Schedule 7, and union have power to make law on the list 9 on the list number 9, entry number 9 in list 1 of the Schedule 7 of the Constitution of India. Now what are the safeguard which has been provided to article which has been provided? So safeguard, because you have arrested on the mere possibility, then there should be a safeguard which should be provided to you. So what are the safeguard? Let's discuss in detail. Safeguard provided for preventive detention. So what are the safeguard? Let's read Article 22 clause 5. So Article 22 clause 5 says that when any person is detained in pursuance of any order made by any law providing for preventive detention, the authority making the order shall as soon as may be communicate to such person that the ground on which the order has been made, and shall afford him the earliest opportunity of making a representation against the order. So basically Article 22 clause 5 says that person who have arrested under preventive detention, person who arrested under preventive detention have the right to be informed, so should be informed the ground of their detention, and also states that reasonable opportunity to defend may against representative detention. So basically, Article 22 Clause 5 says that person who have been arrested under the preventive detention have the right to get informed the ground of their detention. First. Second, he have the right to represent himself for their detention. So these are the two grounds which has been mentioned in under Article 22 Clause 5. Next, what are the time limit? That is the first safeguard. What is the second safeguard? Article 22 Clause 5 says that person who have arrested under the preventive detention have the right to get informed of their detention ground and also have the right to get reasonable opportunity to defend its detention. And Article 22 Clause 4, what is the time limit? Time limit on preventive detention. What is the time? Basically you have detained, आपने डिटेन तो कर लिया किसी पर्सन को, अब आपने कितने दिन की डिटेन किया ये तो आपने बताया ही नहीं. So basically what is the time limit which has been imposed by the legislature? So basically prevention prevention time beyond 3 months, you have to, you need to have, you need to have approval of advisory body. So basically, if you are arresting any person for more than 3 months, then you should require an approval of an advisory body. But for the 3 month, under Article 22, Clause 7, Subclause A, without approval of advisory body, you can arrest for 3 months. That is the basic. So again, one more thing to remember, that Parliament by law can, in cases say detention can be beyond 3 months without approval of advisory board. So basically Parliament by law can do it. So first safeguard has been provided that detention person have the right to get informed of their ground. Second, person to represent himself on the detention ground. Second, time limit, basically for within 3 months you don't need to require any permission of the for the advisory board. For more than 3 months you need to require the permission of the advisory board. But parliament can by law, basically if parliament can do it, that parliament can extend the detention beyond 3 months without approval of advisory board, but it can be done by the law only. Basically, therefore, for this to be done, parliament required to pass a law by the simple majority. So that's basically that can be happen. by the Supreme Court. Now, Article 22, Clause 6 says that. What is Article 22, Clause 6? Article 22, Clause 6 is exception to this provision. Basically, what is the exception? Article 22, Clause 5 says that person have the right to inform the ground on which detention has been happened. But Article 22, Clause 6 says that authority making detention may refuse to disclose ground for the purpose of public order, purpose for public interest. So basically, it may be a possibility that state or parliament or the authority which uh, have arrested you on the ground of preventive detention can also deny to disclose the ground on which detention has been happened. So basically, it is exception to the Article 22 Clause 5. So now we have discussed Article 22 in detail. I think it should be clear to you. Article 22 Clause 1 we have discussed where what is this? It says Article 22 Clause 1, it says that any person with respect to arrest who have arrested have the right to get informed of the ground, and arrested person have the right to consult with the legal practitioner. Article 22 Clause 2 is basically for the punitive detention, and police have who have arrested the person should present the person before the magistrate within the 24 hours. And Article 22 Clause 3 says that all the safeguard which has been given to Article 22 Clause 1, Article 22 Clause 2 will not apply for the alien person. Alien person basically means a person from whom India is in war. And also it states that safeguard which has been provided for the Article 22 Clause 1, Article 22 Clause 2 will not be extended to preventive detention. Now we have studied about the various offences: cognizable offences, non-cognizable offences, bailable offences, non-bailable offences, and other preventive or other offences. Now we have also discussed about the preventive detention. Basically, preventive detention is the basically means you have arrested a person on the mere possibility of committing a crime, not after the committing the crime. Basically, you have arrested before committing the crime on the mere possibility. So Article 20, so there should be a safeguard should be given to you because you have arrested on the mere possibility. So Article 22 Clause 5 says that person who have arrested under the preventive detention have the right to get informed of their detention, plus have the right to defend himself against his detention. But Article 22 Clause 6 is the exception to this article. Basically, it says that authority who have detained you can also deny to disclose your ground for the purpose of public safety, for the purpose of public interest. Plus, there should be a one safeguard also, that time limit has been imposed on the preventive detention. Basically, you can detain a person for only 3 months. For beyond 3 months, you require the approval of authority. What is that authority? Advisory committee. But Parliament by law can extend the 3 month can extend the prevent detention beyond 3 months without the consult of the advisory body. So these are the basically provisions which has been given to under Article 22 Clause 7 under preventive detention. So what is एग्जाम्पल के तौर पर अगर अपन बात करें, एग्जाम्पल के तौर पर डिटेंशन होता है यूएपीए के तहत, एनएसए के तहत डिटेंशन हो जाता है, या मीज़ा के तहत डिटेंशन हो जाता है, अब तो नहीं बचा ये, या एमसीओ सीए के तहत डिटेंशन हो जाता है। तो ये सारे एग्जाम्पल है, इनके तहत अगर डिटेंशन होता है तो अपन को ये हो सकता है। अच्छा, इसके बस अगर अपन इसकी क्रिटिज्म भी तो हो सकते हैं कि भाई ये क्रिटिज्म है तो हाँ, अगेंस्ट इट इज यूज्ड इन वेरी frequent manner or politicization has been happened, this misuse or affecting freedom even only on mere possibility. So basically that is the criticism. What does the favor? You can also state that in the favor of preventive detention, basically various other countries also adopted or require because of terrorism, etc. So these are the requirement also for the preventive detention of the Constitution of India. Now we will discuss in the next class about the Article 21 of the Constitution.